Michigan Real Estate Agency Relationships. Question 1. During a lease negotiation in Dearborn, a listing licensee encounters a rule involving the effect of compensation on determining agency. Which response follows Michigan law? While the file concerns a office condominium, a brokerage policy manual, and a property minus management payment? Option A. Only cash compensation creates agency. Option B. Commission creates dual agency automatically. Option C. The payer is always the client. Option D. Payment alone does not decide whom the licensee represents. The correct answer is option D. Payment alone does not decide whom the licensee represents. Agency depends on the relationship and disclosures rather than the source of money alone. A written office procedure should produce the same result in comparable transactions. The form of compensation does not replace the need to identify the actual principal. Question 2. A property manager is preparing for a seller consultation in Battle Creek. Which statement correctly addresses the agreement that defines brokerage services for a client, while the file concerns a condominium unit, a continuing minus education certificate, and a delayed possession term? Option A. A written service provision agreement. Option B. An unsigned advertising draft. Option C. A tax assessment notice. Option D. A verbal promise from a customer. The correct answer is option A. A written service provision agreement. Michigan brokerage services are organized through an agreement identifying the relationship and services. In the described setting, the brokerage should document the step and apply it before moving forward. A public advertisement or assessment record is not a substitute for the brokerage contract. Question 3. Which Michigan requirement should control when a new applicant deals with the function of a limited service agreement during a listing presentation, while the file concerns a retail suite, a closing statement, and a cooperating brokerage? Option A. Authorize unlicensed practice. Option B. Remove every duty of honesty. Option C. Permit specified services to be knowingly waived in writing. Option D. Transfer the broker's license to the client. The correct answer is option C. Permit specified services to be knowingly waived in writing. A limited minus service arrangement narrows selected brokerage services through a documented waiver. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Core legal obligations and licensing requirements are not erased by the reduced scope. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 4. At a buyer consultation, the brokerage discusses the purpose of a property management employment contract. Which conclusion is most accurate? While the file concerns a manufactured home site, a fair minus housing complaint record, and a rejected counteroffer? Option A. Transfer title to the property manager. Option B. Replace all lease agreements. Option C. Define the broker's management duties and handling of property funds. Option D. Create a mortgage lien. The correct answer is option C. Define the broker's management duties and handling of property funds. Property management for another is based on a written employment arrangement. For exam purposes, focus on the regulated relationship rather than an informal business custom. It does not convey ownership or eliminate contracts with tenants. Question 5. A compliance question in Kalamazoo concerns a licensee selling property in which the licensee has an ownership interest. Which action or statement is appropriate? While the file concerns a 2-unit rental, a brokerage policy manual, and an assumed business name. Option A. Disclose the ownership interest and licensure in writing before an offer is signed. Option B. Tell only the lender orally. Option C. Conceal the interest if the price is fair. Option D. Disclose only after closing. The correct answer is option A. Disclose the ownership interest and licensure in writing before an offer is signed. A buyer must receive advance written notice when the seller is also a real estate licensee with an interest in the property. The transaction context changes the facts, but it does not change the underlying licensing duty. Fair pricing does not excuse non-disclosure. Question 6. How should a Michigan licensee handle a situation involving the purpose of a seller property condition disclosure, while the file concerns a historic residence, a continuing minus education certificate, and a security minus deposit question? Option A. Transfer title to the buyer. Option B. Provide the buyer with required information about known property conditions. Option C. Guarantee the property will never need repairs. Option D. Replace the buyer's inspection. The correct answer is option B. Provide the buyer with required information about known property conditions. A statutory condition statement communicates the seller's knowledge about covered aspects of the property. A written office procedure should produce the same result in comparable transactions. The document neither substitutes for due diligence nor conveys ownership. Question 7. Which choice best applies the state rule concerning a known material defect that affects a purchaser's decision to a brokerage audit, while the file concerns a student rental, a closing statement, and a dual minus representation concern? Option A. Remove it from every transaction file. Option B. Describe it as confidential pricing data. Option C. Communicate the material information as required rather than conceal it. Option D. Hide it until after possession. The correct answer is option C. Communicate the material information as required rather than conceal it. Material property information can affect value, safety, or a reasonable buyer's decision. In the described setting, the brokerage should document the step and apply it before moving forward. Deleting the fact from a file does not remove the underlying duty. Question 8. A file from Pontiac raises an issue about a seller disclosure form compared with a professional inspection. Which answer identifies the governing requirement, while the file concerns a vacant commercial parcel, a fair minus housing complaint record, and a protected minus class inquiry? Option A. The form makes all contingencies void. Option B. The disclosure does not replace an independent inspection. Option C. The form is an appraisal. Option D. The form guarantees structural soundness. The correct answer is option B. The disclosure does not replace an independent inspection. The seller statement reports knowledge rather than providing a complete technical evaluation. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Appraisal and contingency rights serve different purposes. Are you looking for real estate actual questions? Visit our website pokerexams.com to access real estate study guide with actual questions and answers. Scan the QR code or click the link in the description to get real estate answer key today. Question 9. Before completing a renewal review, which rule should the employing broker apply to keeping a client's confidential negotiating information private, while the file concerns an industrial site, a brokerage policy manual, and a disputed repair credit? Option A. A fiduciary responsibility subject to legal disclosure exceptions. Option B. A duty owed only to competitors. Option C. An optional courtesy after closing. Option D. A reason to hide known hazards. The correct answer is option A. A fiduciary responsibility subject to legal disclosure exceptions. Agency loyalty includes protecting confidential information obtained through representation. For exam purposes, focus on the regulated relationship rather than an informal business custom. It cannot be used to conceal material facts that must be communicated. Question 10. A Michigan exam candidate reviews a scenario involving presenting offers and material transaction information promptly. Which option reflects the current licensing framework, while the file concerns a new construction home, a continuing minus education certificate, and an electronic signature? Option A. A task reserved for the assessor. Option B. Optional when commission is small. Option C. A prohibited communication. Option D. Part of competent and loyal client service. The correct answer is option D. Part of competent and loyal client service. Clients need timely information to make informed decisions about offers and risks. The transaction context changes the facts, but it does not change the underlying licensing duty. The size of compensation does not reduce professional responsibility. Question 11. The broker's policy manual addresses a right minus to minus list agreement that binds future owners for an excessive period. Which provision should it contain, while the file concerns a mixed minus use building, a closing statement, and a referral arrangement? Option A. Potentially unenforceable under Michigan restrictions. Option B. Automatically superior to every mortgage. Option C. Required in all residential sales. Option D. A substitute for a deed. The correct answer is option A. Potentially unenforceable under Michigan restrictions. Michigan limits certain long minus term agreements that encumber future home minus sale listing rights. A written office procedure should produce the same result in comparable transactions. The arrangement is not a deed or a universal listing requirement. Question 12. A regulator asks about a listing agreement that discriminates on a prohibited basis during a brokerage review. Which response demonstrates compliance, while the file concerns a cooperative unit, a fair minus housing complaint record, and a team social minus media post? Option A. The broker must follow it without question. Option B. The discriminatory provision or conduct is unlawful. Option C. The clause becomes valid after advertising. Option D. The clause controls if the seller requests it. The correct answer is option B. The discriminatory provision or conduct is unlawful. A client instruction cannot require a licensee to violate housing civil rights law. In the described setting, the brokerage should document the step and apply it before moving forward. Private preference does not override public legal protections. Question 13. Which statement would be safest for a new applicant to follow when the minimum age for an initial salesperson applicant becomes relevant, while the file concerns a farm parcel, a brokerage policy manual, and a record inspection request? Option A. At least 21 years old. Option B. At least 16 years old. Option C. At least 19 years old. Option D. At least 18 years old. The correct answer is option D. At least 18 years old. Michigan requires an initial salesperson applicant to have reached legal adulthood. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Higher age thresholds are not part of the current salesperson checklist. Question 14. A dispute arises during a team training over the approved education needed before examination eligibility. Which principal resolves the issue, while the file concerns a lakefront cottage, a continuing education certificate, and a branch office distance issue? Option A. A complete 24 hours of approved education. Option B. A complete 90 hours of broker education. Option C. Complete 60 hours of continuing education. Option D. A complete 40 hours of approved pre-licensure education. The correct answer is option D. Complete 40 hours of approved pre-licensure education. The salesperson pathway begins with 40 approved instructional hours. For exam purposes, focus on the regulated relationship rather than an informal business custom. Broker coursework and renewal education serve different licensing purposes. Question 15. In Novi, a branch manager must decide how to proceed with the civil rights component within salesperson pre-licensure education. Which decision is consistent with Michigan requirements, while the file concerns a townhouse, a closing statement, and a financing contingency? Option A. Include 8 hours of appraisal only. Option B. Include a federal tax workshop. Option C. Include at least 4 hours on civil rights law and equal opportunity in housing. Option D. Include 1 optional ethics seminar. The correct answer is option C. Include at least 4 hours on civil rights law and equal opportunity in housing. A defined portion of the qualifying course addresses housing equality and civil rights law. The transaction context changes the facts, but it does not change the underlying licensing duty. An unrelated elective does not satisfy this subject specific mandate. Question 16. Which exam answer accurately classifies the rule involving the examination provider used for the Michigan salesperson test, while the file concerns a urban infill property, a fair housing complaint record, and an unrepresented consumer? Option A. Pass a county assessor examination. Option B. Pass the salesperson examination administered by SI. Option C. Pass only a school final examination. Option D. Pass an examination administered by the employing broker. The correct answer is option B. Pass the salesperson examination administered by SI. Michigan uses an independent testing vendor for the salesperson licensing examination. A written office procedure should produce the same result in comparable transactions. An employing broker may sponsor the applicant but does not administer the state examination. Question 17. A new policy is being drafted for the step that produces the candidate identification needed to schedule the test. Which language belongs in the policy, while the file concerns a subdivision lot, a brokerage policy manual, and a confidential price limit? Option A. Submit the online salesperson application and education proof first. Option B. Wait until a license is issued. Option C. Ask a broker to create the candidate number. Option D. Schedule with SI before applying. The correct answer is option A. Submit the online salesperson application and education proof first. Exam eligibility is connected to the online application record and verified course completion. In the described setting, the brokerage should document the step and apply it before moving forward. The identifier is not created by a school or a prospective employer. Question 18. During team training, the supervising broker tests knowledge of the employment relationship required before an active salesperson license is issued. Which answer should the team select? While the file concerns a rural acreage, a continuing education certificate, and a change of employing broker? Option A, use a title company as the statutory employer. Option B, work independently without a broker. Option C, obtain sponsorship from a licensed individual broker or broker company. Option D, register with a local board only. The correct answer is option C, obtain sponsorship from a licensed individual broker or broker company. A Michigan salesperson practices through a licensed employing broker. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Independent brokerage activity requires a different level of licensure. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass in payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 19. A consumer asks the brokerage to explain the number of brokers to which a salesperson may be licensed at one time. Which explanation reflects Michigan law, while the file concerns a single family residence, a closing statement, and an owner licensee conflict? Option A, no broker after passing the examination. Option B, any number of affiliated brokers. Option C, one employing broker. Option D, two brokers if both consent. The correct answer is option C, one employing broker. The salesperson license is tied to a single employing brokerage at a time. For exam purposes, focus on the regulated relationship rather than an informal business custom. Consent between firms does not create an exception to the one-employer structure. Question 20. Which compliance step is required when the transaction facts involve whether a person may simultaneously hold salesperson and broker licenses, while the file concerns a small apartment building, a fair housing complaint record, and an expired license issue? Option A, both are allowed if issued in different counties. Option B, both licenses may remain active indefinitely. Option C, the restriction applies only to associate brokers. Option D, the person may not hold both license types at the same time. The correct answer is option D, the person may not hold both license types at the same time. Michigan separates the salesperson credential from broker level licensure. The transaction context changes the facts, but it does not change the underlying licensing duty. County location does not alter the statewide licensing classification. Question 21. A listing licensee notices a potential problem involving the usual validity period of initial salesperson pre-licensure education. Which response should occur first? While the file concerns a office condominium, a brokerage policy manual, and a property management payment? Option A, 30-6 months from course completion. Option B, 6 months from enrollment. Option C, 1 year from application. Option D, 5 years from examination. The correct answer is option A, 30-6 months from course completion. Initial salesperson coursework remains usable for a 3-year period after completion. A written office procedure should produce the same result in comparable transactions. The examination and application have their own shorter validity periods. Question 22. The state portion of the exam presents facts about the usual validity period of a passing salesperson exam result. Which result is supported, while the file concerns a condominium unit, a continuing education certificate, and a delayed possession term? Option A, 3 years from testing. Option B, no expiration after passing. Option C, 1 year from the passing date. Option D, 90 days from testing. The correct answer is option C, 1 year from the passing date. A passing licensing score is time-limited even though it has been reported to the application. In the described setting, the brokerage should document the step and apply it before moving forward. Course validity and license cycle length do not extend the score period. Question 23. Which brokerage practice properly addresses the usual validity period of a paid salesperson application in the Pontiac transaction, while the file concerns a retail suite, a closing statement, and a cooperating brokerage? Option A, until the applicant chooses to reactivate it. Option B, 1 year from the payment date. Option C, 2 years from course completion. Option D, 30 days from submission. The correct answer is option B, 1 year from the payment date. The online application remains open for a defined 12-month period. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. A valid course certificate does not keep an expired application open. Question 24. A licensee is comparing four procedures related to the requirement for a non-Michigan resident applying for a salesperson license. Which procedure is lawful, while the file concerns a manufactured home site, a fair housing complaint record, and a rejected counteroffer? Option A. Establish a Michigan homestead. Option B. Submit a consent to service of process. Option C. Appoint a county assessor. Option D. Open a branch office. The correct answer is option B. Submit a consent to service of process. A non-resident applicant must provide a mechanism for legal process connected to Michigan regulation. For exam purposes, focus on the regulated relationship rather than an informal business custom. Residency in the state is not itself a condition for salesperson eligibility. Question 25. At the end of a property management meeting, the parties question the allowed address arrangement for a salesperson or associate broker. Which statement provides the best guidance, while the file concerns a 2-unit rental, a brokerage policy manual, and an assumed business name? Option A. An out- state address automatically voids the license. Option B. Every licensee must use a storefront. Option C. Only a broker company may use a post-office box. Option D. A post-office box may be used. The correct answer is option D. A post-office box may be used. Individual salespersons and associate brokers have more flexible address options than brokerage offices. The transaction context changes the facts, but it does not change the underlying licensing duty. The mailing choice does not remove non-resident service process requirements.